Welcome back to another episode of Sidebar Social. I'm Dana Stewart.
And I'm Jennifer Grinke. And today we're going to be talking about the biggest mistakes we see people make in their family law cases.
Oh, and there's so many.
And so many.
Yeah, we'll try to highlight some of the big ones that we deal with.
Yeah. What do you think, Dana, is the biggest mistake people make that you've seen?
A big one these days, social media.
Social media every time.
Everybody wants to post their life on social media. Mm-hmm. And first of all, no one really cares what you're doing, but people want to throw it out there anyway.
Yeah.
And then how many times do we see?
Well, you know who cares what you're doing during your case is the judge.
The judge and your ex.
Yeah, your ex. Your ex's family, your ex's friends.
Your ex's attorney.
Yeah.
Yeah. So how many times do we have that happen where text messages are coming in or social media posts, right?
Yeah, almost every case now.
Every case. So here is Exhibit A, right?
Okay.
So we've got a post here saying never too early for shots at 11:13 in the morning. So this text, not from one of our clients, we found this on the internet, but it's a great example, right? It illustrates exactly what we're talking about, people posting things online that they shouldn't be doing when going through a family law case.
If I'm the attorney on the other side, that is going to be my first exhibit. So I'm going to get that client to first admit that they had the kids in their possession. And then bam, Exhibit A.
There you go. Then you win, right?
Yeah.
Well, no, it's a great example though, especially when you have the case where like a parent's not supposed to be drinking.
Yeah.
Or they claim they're not drinking. You know,
Or they're drinking at the supervised visit.
You know, that's even scarier,
That's a good one.
right? Yeah. Then yeah. So the posts like that, or the other one that we see a lot is when they're just going on a rant about the opposing, or about, you know, their ex or soon to be ex, you know, and they just put it all out there on pages on Facebook or whatever. I mean, I think what people have to know is, especially when you're going through a case, like everything you're doing and saying is going to be magnified, twisted, used against you. Even something that you thought was harmless could potentially be used against you, you know? So what advice do you give to your clients when talking about social media and the pitfalls of that?
Don't put anything out there that you don't want the judge to read.
That's
so
good.
Everything you put on social media, everything you're putting in texts, in email, or on some type of co-parenting website, make sure it's something that's appropriate for the judge in your case to see, and that you can explain if you have to testify about it in court.
Yeah, I think that's really good advice. I typically will try to tell people, you know, it's best just to not even put anything out there right now, because again, you don't know what you're going to do or say and how it may be used against you, how the other lawyer is going to try to, you know, twist that around. And it's better to just be radio silent, but a lot of people can't do that. Everyone loves to be on social media. Well, everyone but me.
Yeah.
But yeah.
Dana does not have any social media.
Yeah, other than this.
I have to update him on all the happenings.
She does. You do a good job of that.
Thank you.
But yeah, so that's what I feel like the clients, I mean, I'll tell them that a lot, that just leave it alone for now, you know?
Yeah.
But then they also have to understand is even when the case is over, some people I feel like think, okay, cool, case is over, eyes are not on me anymore. But if you have kids with somebody and then you're out drinking and partying it up, there could be another case that gets opened up, you know? So I try to warn clients about that.
Yeah, I think the opposite's true too. I think some people panic because they have a lot on their social media and they try to delete it all. And that's also a problem because you can't delete any evidence or things that could be evidence in the case. And so I think at the start of the case, I also tell my clients, you know, you can't delete anything. Everything has to be preserved. So while you might not put things going forward, don't delete anything from the past.
Then the other issue we run into is client may delete something, but just because it's deleted doesn't mean it's permanently gone.
That's true.
Then how many cases have we seen where we get a computer forensic company involved and now they're imaging computers and finding things that were allegedly deleted, but you know, they're there, you know, so it can be very problematic.
Follow us and join the conversation on Instagram and YouTube at Sidebar Social. Another issue I see is people commenting on different social media posts. Like somebody will have a post of Bob Marley getting high and they'll like, you know, and that's going to be one of the exhibits you use if you're trying to allege that that person has an issue with drugs around the kids.
Yeah, absolutely. And that's why it's important. So what I'll tell my clients, I feel like you probably do the same thing, especially early on first meeting, they need to tell us everything, right? Tell us all the skeletons. I always tell them, what is everything that you believe the other parent or other spouse is going to say you did or allege against you, whether it's true, imagined, whatever, you know, you got to get into it all. And so I will let them know, like, you've got to tell me if you basically have sent messages to somebody, or if you've posted things out there, we need to know now so we can game plan for that versus it coming out in a hearing, right, as an exhibit.
Yeah.
That's always an issue.
Yeah, definitely. I mean, we need to know if you've done drugs, if you're drinking, if you've done anything, around the kids that you shouldn't have been doing, so that we can prepare you and ourselves for what would happen in the courtroom if that comes up.
Yeah, absolutely. I mean, I've been in the courtroom before, sitting in the back, waiting to go, waiting for my time for a hearing, just watching other hearings. And I've seen things play out where, an attorney basically got ambushed because their client didn't tell them something. The other side knew about it and then put it into evidence, and it just completely tanked the case for them.
Yeah.
So I always try to stress that, like, full disclosure, it's important. We've got to have that trust.
Yeah, and that's another mistake that people make by not telling their attorney everything. Sometimes I think they're embarrassed, or they don't want to talk about what happened, or they think it's going to hurt their case, but we can't prepare them for the courtroom if we don't know what to prepare for.
Yeah, for those watching, your doctor and your lawyer, full transparency. Those are important things. Do not have secrets with your doctor or your lawyer. You agree with that?
Well, unless your doctor's like writing it down and then we subpoena the records somehow. I don't know that I'd want to.
We'll have to get into that on another episode. That's a very good point, though. Yeah, true. Yeah. But very good point.
Yeah.
All right, let's talk about other mistakes that we commonly see. I think another big one is putting the children in the middle of the conflict.
Yep.
So, I mean, we see it in a lot of different ways, but like what comes out a lot is sometimes the parents will use the child as a messenger to go between them. Do you have any thoughts on that?
Yeah, I think a lot of times people think that's okay to do, to say, hey, tell your dad this, or tell your mom this, or I'll pick you up at this time, tell your dad. But it's actually a form of using the kids in the middle of the conflict, because now you're putting the burden on the child to do something that you should have done. And so I think a lot of times it's good to like bring that to light to your client and tell them, hey, just be aware that this isn't something you should be doing during your case, or really ever, but definitely not during your case.
And we, sometimes we'll get parents onto some kind of co-parenting app where they become like their central database for all co-parenting communication. So that way you avoid I didn't get that email about soccer practice, or the text message, So we talk to clients about, hey, we can get you on this app where everything's saved and it's all time stamped, and go through that versus going through your kid.
Yeah, and I think another benefit to that app is the judge can have access to it. The attorneys can have access to it. So people tend to be maybe on better behavior on the app.
Yes.
And you can also see if somebody's read a message or received a message and hasn't read it. So I think it's just an easier way than going through the kids, and it's more effective.
And so then kind of an offshoot of what we're just talking about, another issue is maybe not going through the kids to deliver messages, but disparaging the other parent in front of the kids. I mean, how often do we see that come up?
Yeah, it's unfortunate, but I feel like we see that come up in almost every case. And most counties have something called a standing order that says that the parents are not supposed to be doing that around the children or directly to the children, but somehow it keeps happening.
It keeps happening. And and I know we're going to have a mental health professional on coming up soon.
Yeah.
And we can get into that with her. But what I've always heard from those in that field is when a parent is talking bad about the other parent to the child, a lot of the children will internalize that and think, well, if parent, my mom's bad, well, then I must be bad because I'm from her, and they talk about the deep emotional impact that can have on kids.
Yeah. And I think that the parties and the parents, they don't really realize how much it can affect their case and how much it angers the judge.
Right.
I mean, I can be in a hearing and having it going extremely well, and then one text come in or one recording or something comes in where the judge gets any inclination that the child knows about the case, or heard a parent talk bad, and they just go off the handle. They like switch custody. It's a big deal.
It is. And I sometimes will tell a client, wait, you get that urge to want to say something to your ex or your co-parent. It's that thing that's been, I don't know, advice given for years, I feel like, of write out the email and then delete it.
Yeah.
Or, write it in a journal, then burn the paper or whatever, let it go. I think I always try to tell them, think twice. If you really want to send it, you can have it written, sleep on it, come back tomorrow. If you're not sure, send it to your attorney, let them review it. And it's the much better way to go. Because like you said, the impact of it on the case can be, it can be a lot. It can be devastating.
Yeah. And the kids are so tech savvy now. Like sometimes your own child is recording you.
So. Right. That's true. Yeah. They're better than the parents.
Be very careful with that.
Right. To learn more about Greinke Stewart Family Law, visit GreinkeStewartLaw.com. All right, Jen, a few times you've mentioned the impact that evidence could have on the judge, right? Yeah. So how important do you think it is for us as the family law practitioners to know the specific judge and their tendencies and how that can impact a case?
Yeah, that can have a huge impact on the case because we have to know the judge. We have to know the way that the judge rules. We have to know what makes the judge angry, what the judge likes to see. And if we don't know those things, we can be giving our clients bad advice, or we could be going to the courtroom and presenting evidence that we know or we don't know, I guess, is going to hurt our client in the long run. Like, for example, if your client really, really wants a 50-50 type possession and you go in front of a judge who's spoken and said, hey, I don't do that. I mean, you're just setting your client up to fail in that courtroom. So, I mean, don't you agree it's pretty important to be involved in the counties that you practice in and know the judges?
Yeah, absolutely. And I think that's what we try to do with our firm is we are heavily involved in the counties that we practice, and we do know those judges, so we know their tendencies, the range of what is reasonable to expect if we go to court. And I think that can, at least I feel like that helps us give the clients advice when we're trying to potentially settle a case, like where are we on that spectrum and how likely is that to happen should we go to court? So I definitely agree. You got to know the judge.
Yeah, and I think it also helps prepare the client for what to expect in the courtroom, as well as what to do and what not to do in the courtroom. Like if you're talking over the court reporter or, wearing something we don't think the judge would like, any of those types of things.
Yeah.
No midriffs.
Yeah, no midriffs. We've seen some of those. It's interesting going to court and watching how some of the people come in and then, they just...
Flip-flops?
Yeah, the flip-flops, hat on, a tank top. I've seen it all, and some of those people I feel like maybe didn't have attorneys, so they didn't know what they're supposed to do. But that goes back to what you're saying. You need to get an attorney who can help guide you through all that because the impact of it's very important.
Yeah.
So one of the things we're going to incorporate on these episodes is at the end, we're going to run through a closing argument segment where Jennifer and I are going to basically take on an issue and argue opposing perspectives. And then we'll let you as the audience decide who has the better point, or if we've got a guest in studio, then they can help be the one who makes the decision, essentially act like the judge. So what are we going to be arguing today, counselor?
Today, the hot topic is dating apps, for or against.
Oh, okay.
So here's a scenario. My client's the wife. She's in the middle of a heated divorce, and she is on a dating app and has been going out with different people.
How dare her?
Your client is the husband. He's against dating apps.
He's heartbroken over this.
Yeah, he's heartbroken.
Okay, I got it.
He probably hooked up with the tennis pro, so I don't know.
That was one time.
Yeah.
But go ahead. Okay, I'll let you, you can take the floor first.
Okay. My client has been going through a divorce now for 2 years. She has been single. She recently got on dating apps. There was no adultery on her end during this marriage. We can't say the same for the husband. But adultery in Texas has to be the cause of the breakup of the marriage for fault grounds. She did not do that until the divorce had been proceeding, and so therefore she should be allowed to date. She's not spending any money on this person. In fact, she's probably making the estate money because he's paying for all her meals and purses.
All right. 2 years. That delay is because she continues to refuse to turn over documents, right? And so I think the documents could potentially show that maybe she is spending money. But the bigger concern that my client has is she's going to bring this guy around their children. And he's upset about that. He doesn't want them meeting this gentleman, and now he's the new daddy. I think that's wrong. And I think the judge is going to be sympathetic to that. Your client needs to wait. There's a trial coming up soon. She can hold off, and then she can go with this fling with the tennis pro. It'll be fine later.
All right, that was the closing arguments. But in all seriousness, Dana, what would you advise your client in this situation?
Well, I will say I think your arguments were pretty valid and strong. But
so
you probably won that. But if I represented your client, what I would let her know is, even though you could argue it well in front of a judge, the impact it can have emotionally on dragging the case out and what it may do to her soon-to-be ex and the issues it could cause for the kids. Just trying to, I get it. She wants to move on and basically get to a place where she's starting her new life. But the fallout from that, I think emotionally could be difficult, especially if there's young kids. She's still going to have to co-parent. He's not going to let that go, and it's going to cause more issues. So I would still try to encourage her to just keep that on pause for a little bit.
Yeah, I think that makes sense.
All right, we want to know what you think at home. So share your thoughts in the comments below, and we will see you next time on Sidebar Social.